Good morning. On behalf of Four Pump Court, Jones Day and Dentons, welcome to this session. A couple of housekeeping points before we get going. First of all, this session is being recorded, and with the slide pack, it will be sent out by email to all registered delegates. Secondly, we expect to have a few minutes for questions at the end of the session. If you have a question, please enter it by clicking on the Q&A button at the bottom of your screen at any point during the session. So our subject this morning is demand bonds and performance guarantees. Those are species of security which are typically provided by third parties to a project, such as banks or insurance companies. Third-party securities, of course, are perennially attractive to developers and funders. They want security which will generate liquid funds in the event of contractor default. And third-party securities are significantly less vulnerable to contractor insolvency, for example, than parent company guarantees or similar. So for such reasons, even at the best of times, demand bonds like letters of credit have been recognised as the lifeblood of international commerce. But of course, the last 18 months have not been the best of times. The turmoil generated by the pandemic has had consequences in fields in which demand bonds and performance guarantees are common, such as the construction sector. Restricted site operations have led to project delays, to contractor insolvencies, to project contract terminations. And events of that sort have led to an increase in the frequency of calls on bonds and guarantees. So the principles which govern the interpretation and the operation of these instruments are currently of great importance. They've been the subject of recent judicial scrutiny in various jurisdictions. We'll hear this morning from two speakers who have exceptional expertise in this area. James Pickavance is head of the construction and infrastructure practice at Jones Day in London. He handles complex domestic and international construction and engineering matters, primarily in the energy, power, major infrastructure and commercial development sectors. James has been instructed to call or defend on-demand and conditional bonds at least a dozen times under English and foreign laws. Most recently, I understand, last month in the Middle East. James is a committee member of the UK Adjudication Society. He's a board member of the International Construction Law Association, and he's a visiting fellow at King's College London, where he teaches on the master's course in construction and engineering. Simon Hale is a highly regarded junior who practices from Four Pump Court in domestic and international construction and energy disputes. He's appeared in leading authorities concerning bond calls, two of which you will hear about this morning. He's also written extensively on the subject, including an excellent paper published earlier this year, which is available on the Society of Construction Law's website. Quotes from Simon's clients in the professional directories include the observations that he possesses gravitas beyond his age, and that he is brilliant and incredibly bright, just good at everything, and a very impressive advocate. Having led Simon in a couple of rather demanding matters, I fully endorse those observations. We were also to have been joined by Niall Clancy of Dentons. Unfortunately, as of yesterday, Niall is indisposed, so James and Simon will speak to his slides. Niall is the lead senior associate in Dentons dispute team in Qatar. He's practiced from Doha since 2016. He's acted for parties from the Middle East, the UK, Eastern Europe, Asia, North America, and Africa in arbitrations concerning large infrastructure projects. And Niall appeared with Simon for the successful party in Leonardo and Doha Bank, a very important recent decision of which you will hear more this morning. Could I have slide 3, please? Thank you. We've divided the topic this morning into 3 small slices and 3 larger slices. Part 1 comprises the 3 small slices. In this part, we have attempted to gather together some introductory considerations. First of all, Simon is going to introduce some core concepts and the typical parties to a demand bond or performance guarantee. Then James will introduce some highlights from the ICC Uniform Rules on Demand Guarantees, the URDG. And then James will round off part 1 with a look at the broader context, explaining why these matters are particularly important in the light of the economic challenges currently faced by the sector, and also how approaches and attitudes vary between different jurisdictions. So I'll hand over first to Simon for the first slice of part 1.
Good morning, everyone. Well, as Fiona said in her introduction, we are dealing with forms of security for the performance of obligations arising under a separate contract, typically a construction contract, a construction subcontract, but the contexts are myriad. That separate contract is usually referred to as the underlying contract or as creating the underlying relationship, and the bond sits to one side. Now, this is an area where terminology does matter, but it's also an area where terminology is not always consistently used, either in the authorities or indeed in the bonds with which we have to deal themselves. The terms that I prefer are, on the one hand, demand bonds, and on the other hand, performance guarantees. Partly that is to create a separation in the ear, but it's also because those labels signpost what will tend to be the center of gravity of a dispute on each type of instrument. For a demand bond, the payer is bonded to meet a complying demand. The key questions in those cases usually turn on the validity or the integrity of the written demand itself. In contrast, under a performance guarantee, the payer has agreed to guarantee or underwrite a particular level of actual performance. And the key questions and disputes in those cases usually relate to whether that actual level of performance has or hasn't been provided. Across the piece, there are typically 3 protagonists, some variant on what is shown on this slide. There will always be a principal. That's the party whose performance is being guaranteed and which has to perform obligations under the underlying contract. There will always be a payer that does what it says on the tin. It's normally a bank, but it can be a parent company, an insurer, and so on. And then there is the beneficiary. That's the party with the right to make a call on the demand bond or the performance guarantee. There can be many other parties in the chain. There are often chains of banks, but that trio is the core. Next slide, please. Although the 2 different types of instrument are contextually associated, they are legally fundamentally different. And I've tried to juxtapose the key distinctions on this slide and the next. And we see that in a lot of ways, the 2 different types of instruments are really the mirror inversion of each other. These first 3 ideas on this slide are all expressions of the same core point. Firstly, demand bonds are instruments of primary liability. And by that, I mean that the bank or the payer is liable to meet a valid demand, irrespective of whether there's a corresponding coextensive liability in the underlying contract. There is a metaphorical shutter drawn down between the underlying contract and the bond, and they are for most purposes kept entirely separate. And that is the principle of autonomy. In contrast, performance guarantees, well, there is no shutter. They are instruments of secondary liability, and that means they only activate if there is within the underlying relationship an actual state of liability in the project. And in that sense, liability is not autonomous. It's entirely dependent on there being liability between the underlying parties. A further consequence of this distinction, of this shutter, if you will, is that in a demand bond context, a bank or payer's field of vision is very narrow. Their primary liability to pay is triggered by the presentation of complying documents, and that is it. Not notably the written demand. They have no legitimate interest and usually are expressly prohibited from inquiring into the actual state of performance on the project, be it construction or any other. And as I think has been noted, that will often be something that's very seriously disputed. The bank looks at the documents. Performance guarantees, in contrast, again, there's no shutter, and so the guarantor's field of view is very wide. It could inquire into the actual contractual position as its liability only arises against an actual situation of liability. Next slide, please. And those different fields of view affect the range of defences that the payer has. In the demand bond context, there aren't many. We will deal in due course with the question of the fraud exception. But beyond that, if the demand is compliant, there is very little that a demand bond payer can do. But compliance of the demand is obviously very important. Contrast that under a performance guarantee, at least in English law, there are a plethora of equitable defences available at common law, and often performance guarantees contain bespoke terms dealing with which of those defences are and are not available as agreed between the parties. A further distinction is their international harmonisation. James will deal in a moment with the URDG applying to demand bonds. There's no equivalent harmony for performance guarantees. And in a practical sense, the implication of everything I've said is that in general, the enforcement of the demand bond ought to be quicker, simpler, and more certain when compared with the potential for enforcement of a performance guarantee to be slower, more complex, and less certain. But of course, the exception proves the rule, and we'll deal with some cases that look at how that plays out in practice. But James, I think you're going to speak to the URDG next.
Thank you, Simon. Next slide, please. Yeah, I just want to say a few words about the ICC uniform rules on demand guarantees. These are a set of rules that we increasingly see incorporated into demand bonds, and usually the incorporation is buried away in the wording of the bond, and it will say that the bond is to be interpreted in accordance with URDG 758, and of course that imports the rules in that instrument. And so when construing demand bonds that incorporate URDG, it is absolutely crucial that one looks at both the bond and URDG. So it's an international set of rules that are often incorporated. They codify law and international practice applicable to bonds, and their design really is to curb unfair calls and balance competing interests. As the slide says, the second revision was published in July 2010. There's been no update since that publication, at least to this form. And when one considers URDG 758, one can see that it does adopt certain elements of the letter of credit practice, that's UCP 600, in its drafting, although one doesn't need to look at UCP to interpret the provisions of URDG. Next slide, please. There are 20 or so rules in the URDG, but I just want to focus on three of them, or three core concepts. The first is the independence or autonomy principle, and that's set out at Articles 5 and 6, and that really repeats its predecessor's attempt, the first edition's attempt, to confirm that the independent nature of the bond or the guarantee by specifically excluding any rights that a guarantor may have to defences or counterclaims which are derived from the underlying contract. So the interpretation of the bond is when the URDG rules are imported, and possibly even when they're not, is strictly on the basis of the bond wording itself. That's not to say the contract and the requirements in the contract are not relevant, and we'll come back to that. The documents principle, Article 6 and Article 7, really the point here is that non-documentary conditions are void. What the bank is really concerned with, that is the payer, what it's really concerned with is have the requirements of the bond been complied with, and have the correct documents been lodged with the bank in order to give way to payment. And Article 7 is quite clear on that. Fiona said that Simon and Niall were party representatives in the Leonardo and Doha Bank case, and that is an important case for both in terms of understanding how demand bonds work, but also understanding how URDG interacts. And on the slide there, you can see the strict compliance principle, which Leonardo sets out, and the court held that documents presented must strictly conform to the requirements of the guarantee, and if the documents do not comply, their presentation will be a non-complying presentation, even if the discrepancy has no practical effect. And really that's an application of URDG, but more than that, the court recognised in that case, and indeed in other cases, that demand bonds are fairly draconian instruments. The purpose of the bond really is to act like a cash payment when it's called, and so because of the draconian nature of the bond, what the court said in that case is strict compliance with the requirements of the bond is absolutely necessary. Next slide, please. So a couple of articles concerning how one goes about making a demand. Article 15 deals with supporting statements, and it requires that demand should be supported by such other documents as the bond specifies, and in any event by a statement by the beneficiary indicating in what respect the applicant is in breach of its obligations. And there's often some confusion there, in my experience, as to how far that statement needs to go. Does the beneficiary need to set out almost a submission as to why the principal is in breach? Does it need to set out the details of its loss, the loss that it suffered? And in my view, certainly in the case of demand bonds and subject to the requirements of the contract, the answer is no. It is a brief statement setting out why the beneficiary is in breach, and nothing more is needed. Turning then to the bank or the payer's obligations, Article 19 deals with the presentation alone. So the guarantor shall determine on the basis of the documents that have been presented whether it's a compliant presentation. I mentioned a moment ago the Leonardo case, really to emphasise that when one is making a call under a demand bond, you should check, double check and triple check that every aspect of the requirement of the bond has been met. The second point is payments. Now, payments under URDG terms needs to be made very quickly. It's within 5 days if the demand is compliant, and that's important if the bank procrastinates or delays for whatever reason, and I'll come on to an example of that in due course. Article 24, rejection notice and preclusion. So when the guarantor rejects a demand, it needs to give a single notice to that effect to the beneficiary presenter, and the notice shall state why that demand has been rejected. And sometimes it'll be an error which is easily fixed, but of course, often demand bonds are called without notice. Sometimes there's a requirement to give notice, but often there isn't. And so if one doesn't get the documents correct first time round, then of course the principal is on notice, and one may find oneself subject to an injunction call, and we'll get onto that in a moment. Next slide, please. So I just wanted to touch on the current situation, and Fiona's dealt with this a little bit in the introduction. Certainly in my career, at the start of my career, the demand bonds were really the bogeyman of security. You sort of had it in the cupboard, it was there, but nobody ever really pressed the nuclear button. And if you did press the button, or rather call the demand bond, it was very bad for that beneficiary's reputation. So really, until more recently, and certainly over the past 18 months, one's sort of attention as to the law surrounding demand bonds was a bit like the attention one had on force majeure before March 2020. We knew a bit about it, but there wasn't, demand bonds weren't a focus of one's practice, but that's changed. Why has it changed? Well, I think even as recently as over the last decade, contracting has really kicked up a gear in how it operates as an international global practice. Insolvency, I think, certainly over the last 18 months has become more prevalent, and people have started actually calling these bonds, and as a result, we've had to come to terms with what the bonds, how to call bonds, how to interpret them, and there have been disputes about that. Hence the two recent cases that Simon has been instructed on. I think cash flow pressures on all parties in projects remains, notwithstanding that at least in this country we're climbing out of, or dare I say, hopefully climbing out of COVID, but of course that's not the case in many other parts of the world. And the effect of COVID is going to be with us for some time, we suspect. So it is not the case that the financial pressures on these companies is going to alleviate. As to the regional trends, I have some experience of calling bonds in different jurisdictions, and of course Jones Day has a network across the globe, and I've had discussions with my partners about regional trends. I think at the moment it is a fairly unified message, and that is that there has been a shift away from conditional bonds and a move towards demand bonds, and that demand bonds are certainly being threatened and very often called, and sometimes those demand bonds are for serious amounts of money. I can think of one instance of a client that agreed to a bond in the hundreds of millions, and its joint venture partner went insolvent on a very large project, and the beneficiary of the bond called it, and that placed the company, the principal, in a great deal more pressure than it was already under. So these things are happening, and I think this presentation is quite timely, and we all need to pay more attention, I think, to how bonds, and in particular demand bonds, are to be interpreted. And with that, I think I will pass back to Fiona momentarily. Next slide.
I think you're muted, Fiona.
Sorry. We hope that with those starter topics, we'll have whetted your appetite for the second part of this session, which is a look in greater depth at some of the key legal principles which govern entitlements and obligations under bonds. The first slice, construction of terms, answers the question which faces principal, payer or beneficiary when there is a prospect of a call on a bond, and that is, what does the wording of the bond mean? So James is going to examine the relevant principles of construction, both where the URDG are incorporated and where they are not. Second slice is the fraud exceptions. In many jurisdictions, including England and Wales, essentially the only ground on which a surety faced with a formally valid, a compliant call on a bond can lawfully refuse to pay is fraud. So Simon will consider the legal and the practical issues which face a party deciding whether to make a case of fraud, and also those which face a party which must meet a case of fraud. And in the final section, Simon is going to look at the injunction jurisdiction. The first and sometimes the only occasion on which fraud is raised is an application for an injunction. Parties invite the court to intervene at various different stages of the process of activating a bond. And they do it, of course, from their respective perspectives. Simon is going to look at features of the court's jurisdiction to grant an injunction, which are specific to this context. So, James, could I hand over to you for the construction of terms, please?
Thank you, Fiona. Let me start with some principles of contractual construction. I want to deal with this very briefly, because this is not a talk about the principles of contractual construction under English law, but of course, as Fiona mentioned, absolutely critical to understand the canons of construction under English law. And we all, when we're thinking about this, we all often mention the seminal cases of Arnold and Britton and Wood and Capita, and that's absolutely correct. But I find a more useful starting point the case on the slide, Lukoil, Asia Pacific and Ocean Tankers, a 2018 case. And I would refer you to paragraph 8 of that decision, which takes in Wood and Capita and Arnold and Britton and sets out, in my view, very clearly what the what considerations a court will take into account. I think the starting point for anyone for bonds, demand bonds that are subject to English law is that contract is king. The words mean what they say, and I'm sure I don't need to tell this audience that is the reason why English law is one of the, if not the most popular choices of law, because certainly in the case of demand bonds, the beneficiary wants to know that when the bond is called, there is going to be no sort of question of interpretation brought into how the bond could be construed, and the terms of the bond that's agreed with the bank and the principal will be applied. And so Lucal says the court will consider the objective meaning of the words, and it will consider all the background knowledge which would reasonably have been available to the parties at the time of contracting. It will consider the contracts, or in this case the bond as a whole, and where there is some inconsistency, it may fall back on an interpretation which yields to business common sense. I think it's important to point out how the courts will consider demand bonds, and they will have, in my view, some recourse to the purpose of the bond, which is, as I said earlier, effectively a cash payment. And so one is going to have to demonstrate fairly clearly that the wording of the bond should mean something other than is written in the bond, if one wants to try and argue that the bond shouldn't be called. So difficult hurdle on construction. Next slide, please. We've talked about URDG, and the Leonardo is interesting for considering questions of construction where URDG was incorporated, and in that case a question of construction arose as to whether a reference to paying sums which Leonardo, which was the beneficiary, might have to a claim in writing from the principal, whether that imposed a condition precedent to liability on the bond, requiring the beneficiary to have made a demand in writing. And the court said in that case that it didn't, but perhaps more importantly for you all are some points of principle that case set out. And the first is that the Court of Appeal said that where the bond features URDG, one needs to move away from a nationalistic focus on rules of construction and adopt an internationally minded outlook. And the URDG, it said, was aimed at fostering precision, certainty, and predictability of outcome. And so that's not perhaps a good argument for nuanced interpretations as to how the clause is to be construed. And in my view, that only reinforces the principles that one would apply if the bond was subject to English law and the URDG didn't apply. We talked about Article 7. Article 7, I think, will remove some issues from construction or influence them. So non-documentary evidence is void. And then Article 24, which is another point that impacts construction. The rejection notice under URDG must stipulate the grounds of rejection, or else they're precluded from reliance. So I think this is a very important case to consider and read. As I said, Simon was heavily involved in it, and the SCL paper that Fiona referred to at the start of the presentation deals with this case, unsurprisingly, deals with this case in some detail. So I would urge you to refer to that paper. Next slide, please. So how does a bond, we've talked about how the bond is an independent instrument and how URDG requires that. But how does the contract, the underlying contract, interact with the bond? Well, the bond and the contract are treated for legal purposes as separate, independent contracts to be interpreted in accordance with their own terms, even though they arise out of the same contract. So it's important to distinguish the terms of the contract and the terms of the bond. But are there circumstances where the terms of the bond may assist? And I would venture to suggest that there are. The terms of the contract may require a notice of default to be issued before the demand bond is called, and the notice of default may provide a remedy period before the bond is called. There may be, and often are, notice requirements in the contract. So is there a form under which the notice is required to be given? Who is the notice required to be given to? And then, even though the instrument, the bond instrument, is on demand, there may be a requirement for a trigger event in the underlying contract. And on the slide is one example of in a case I recently dealt with, where the contract said the beneficiary is entitled to deduct where the loss was caused by negligence, default, or omission under the contract. And so what these conditions or requirements give rise to is two avenues for the principal who is trying to resist a call on the bond. There's the avenue to resist the call on the bond under the instrument itself, and there may be possibilities to resist the call under the underlying contract. Next slide, please. And so next slide, please. And so when considering making a call on a bond, or if you're in receipt of a call on a bond, this is the sort of mantra that I tend to apply, all the things that I tend to think about when I'm dealing with this issue. The first is who. So if we're thinking about making an injunction call to stop the bond, to stop the bond call, is that injunction call going to be on the bank or the surety, or is it going to be on the beneficiary of the bond? And the answer to that the answer to that typically lies with which route you're going down. Are you going under the demand bond, or are you going under the underlying contract? And you may well, and often will, have to think about service outside the jurisdiction, particularly in international contracts that we all deal with. Second is what, how are you going to stop the call on the bond? Well, invariably the answer is an injunction, and the question is, are you calling an injunction under the contract or under the bond? And Simon, I think, is going to deal with that a bit later. Where? So have a look at the law of what is the law of the contract. Often that is different to and very often actually it's different to the law that the bond is subject to. So of course it's going to be necessary to consider whether you're injuncting under, let's say, English law or Swiss law, and then of course the forum is going to be important. So if the disputes are under the bond are subject to the High Court of England and Wales, then the call will be made, the injunction will be made by application to the court. But if the injunction is going to be made under the contract and the dispute resolution procedure is arbitration, well, then you may be using the emergency arbitration procedures under whatever institution the underlying contract provides for. timing of when you make the injunction application will depend. Sometimes you want to stop the beneficiary making the call at all, and so you'll be making an injunction, making an application for an injunction before the bond is even called. That can be quite difficult to anticipate because, as I said, bond calls are generally made without notice. But if the beneficiary gets it wrong, then you may well have time to get an injunction. What are the grounds? Well, at least in English law, it's arguable that an injunction should be granted where the terms of the underlying contract preclude the beneficiary from making the call. And in order for an injunction to be granted on that basis, the courts have said that it must be clearly established that a call would be a breach, clearing the usual sort of arguable case threshold. And the case to look at in that respect is Sirius International, which is shown on the slide there. Enforcement, well, where the entity is a large, reputable international company with business interests in the UK, if that's where the injunction is being granted, in my experience, the company is likely to comply with an English judgment, but it may not, in which case you will have to take action, enforcement action. And enforcement action in the UK has become more complicated, of course, since Brexit. There is no final decision on Lugano. Doesn't look hopeful, but the jury is still out there. Do the transitional provisions still apply? And if so, Brussels recast should assist. Beyond that, one's looking at the Hague Convention, if there's an exclusive choice of law jurisdiction, or if there isn't, then you're looking at the common law in the jurisdiction where you're trying to enforce. That's the EU. More widely than that, it can become difficult. And certainly where one's trying to enforce an award against a state-owned entity, that can be, the courts may well take an unconventional view to avoid enforcing an award, a judgment from an overseas jurisdiction.
Thank you, James. Before we move on to the fraud exception, could I just ask you to expand a little on the position of the bank? Where does the bank sit? Is it passive, or what contractual rights does it and obligations does it have?
Yeah, well, this is interesting because, of course, the bank should look at the look at the documents being presented and make a objective, almost sort of binary call on whether it should pay out or not. And in my experience, at least, it's a little more. The picture is a little grayer than that. So I'll give you an example. We were suing a Chinese state-owned entity, and we called the bond, demand bond, and the bank was a very well-known bank in China, and it delayed on payment and tipped off its client. And the client went to the Chinese courts, getting an injunction which prevented the call, and then the bank didn't pay out. And we brought proceedings seeking discovery on the basis that the bank told their client, and if that had been the case, then that would have been a breach of the instrument, which said that the surety or the bank had to pay out without reference. Now, it just so happened that there were journalists in the audience when we made that application, and let's just say the bank was, and those journalists reported on the outcome in fairly adverse terms against the bank, and needless to say, the bank weren't particularly happy about that. And ultimately, as a result of the adverse publicity it was facing, the bank paid out. But the point that I would make on this is that whilst we're talking about the how demand bonds and how contracts are to be interpreted, and we hope that banks would comply with the terms and honour the terms of the bond. Sometimes it's a little bit more complicated and it can get political, and it just pays to think about that. Next slide, please. So very quickly, conclusions on construction. Think about the canons of construction under the law that the bond is subject to. Think about whether URDG is incorporated into the bond. Don't disregard that. It does import a series of obligations, and as I said earlier, seeks to eliminate ambiguity. Don't only think about the demand bond, also think about the underlying contract and consider what options you've got there. Who, what, where, when, why enforce. I would suggest that might be a checklist that you would want to deploy when faced with a call on a bond, or when thinking about making a call on a bond. I think it's right to say, of course, every case is decided on its own facts, but I think where there is ambiguity, it's likely the bond will be called. And I think the advice that one gives to one's clients when facing a call on an on-demand bond is that the starting point is that the prospects of success are low, because it is difficult to get an injunction for a call on a bond. But I think Simon is now going to go on to explain one way in which it is possible to get an injunction when a bond is called.
Thanks, James. Yes, next slide, please. And just as an aside, there's a number of very interesting questions coming through on the question and answer feed, which I think we'll generally come to at the end, but there's one that's been raised I'll try and deal with in the course of this section. So thank you for those questions. The fraud defence, conceptually a very different area from questions of construction. Fraud is a defence to a call on any type of guarantee, but in practice, its main area of relevance and operation is demand bonds. Let's take a real world example. There is a bond for 20 million US dollars. The beneficiary makes a demand for $10 million because it says that the contractor is liable for delay liquidated damages in that amount. The general position is the bank is not in the least interested in whether that is or isn't right. It's not its concern. But what if the beneficiary a week earlier had written a letter that said, we confirm, contractor, that your liability for delay liquidated damages is $5 million. There you have a scenario where questions start to ring, and there may be a reason for the bank to take an interest. And this is why we call fraud the fraud exception. It's an exception to the rule that a bank or a payer normally takes no notice about what the parties say is the situation on the ground. Exceptionally, the bank can take an interest in those events if it is being said that out of those facts arises a demand that is a dishonest tool of fraud. What does fraud mean? Well, it varies globally. It's a sort of universal concept, but different jurisdictions finesse it in different ways. In England and Wales, when we talk about fraud, we really mean the beneficiary presenting documents that make a material misrepresentation of fact that the beneficiary knows is not true. So fraud is a meeting point of two ingredients. One, that the beneficiary has no basis to be making the demand in the first place, and two, that they know that's the case and that they are being dishonest about it. Now, I do need to stress, when we talk about an exception, we really do mean a very exceptional situation. There are lots of examples in the authorities of language that telegraphs that, a need to prove established, obvious, or clear fraud, unquestionable fraud. These labels give you a sense of how high the bar is set. Next slide, please. But how do fights about that high bar play out in practice? Well, there's two typical scenarios. Number one, that the counterparty, the principal, gets wind of a demand, either that has been made or that's about to be made, and stands up and loudly says, there's no basis for that. That demand is based on false information, and I want to stop it. Another example is that the bank itself is the party that takes the initiative in some way to derail the bond and investigate whether there is fraud. And there are situations where it's almost somewhere in the middle. It sounds a little bit like James's Bank of China case. But whatever the exact dynamics of this, the beating heart in these applications is pretty much the same. And that is, can the challenging party show on the material that's available that the only realistic inference to draw is fraud? Nothing short of that will do. And that is a test that Mr. Justice Fraser, in a case called Tetronics, T-E-T, Tetronics and HSBC, described as requiring extraordinary facts. And I think he's right about that. Just to give you a vignette, a case called HLC Engenaria, that was a case where the beneficiary, so the rights holder, expressly told its agent that, look, there's no basis to call this demand. We haven't got any claims. And its agent said, thanks very much for that, and then called it anyway. Now, in that situation, the court said, that's a fraud because you can't possibly have believed that that was a valid demand. You'd been told the precise opposite. And I just use that as an example of the sort of fact pattern that one is going to have to look for in these cases. And reflect also that it's an extraordinarily high burden at a very early stage. As Fiona mentioned, these issues very often get litigated at the outset in an interim hearing where there'll almost never be oral evidence, and the documents you have to work with are likely to be the ones that you happen to possess, rather than what have been revealed through an inquiry into disclosure. Next slide, please. In the time available, I'm going to do not much more really than just signpost the Leonardo and Doha bank case in which I was involved, and Niall as well, as an interesting reference for anyone who's possessed of a potential fraud allegation or defence in their work, because the facts of that case were reasonably conventional, and so they may provide some precedent and some persuasive value. There's a military project in Qatar backed with two demand bonds, a performance bond whose primary purpose was to meet claims, and an advance payment bond. Now, one of the questions that's been thrown up on the thread is what's the sort of legal status of an advance payment bond? Can it be called or encashed in a similar way to a performance bond? The answer is that as to their legal nature, both of these things were on-demand bonds, but they are targeted at slightly different purposes. An advance payment bond is there to secure the typically the employer's initial outlay of an advance payment. So they are exposed at the start of the project because they've handed over X million and no work's been done. An advance payment bond is really to provide protection for that advance investment. But despite that difference in purpose, their legal nature is generally the same. These are generally bonds that will say it can be called on demand for any reason. Now, as far as the facts go, I'll simply say that on the Leonardo decision, there was a dispute as to whether we had the right to call the performance bond. We terminated the EPC and we made a demand for $4 million. We hadn't actually articulated any claims against the counterparty at that point, and their position was very loudly that they had cross claims that were greater in value. But in the end, when the court looked at the evidence and looked at the test, it concluded that it was just a sort of typical dispute between an employer and contractor, and there wasn't any evidence that tipped the scales in favour of a fraud finding. And similar really in relation to the advance payment bond, if anyone is dealing with an allegation of fraud on an APB, and they can sometimes relate to whether the amount of the bond has been stepped down properly, Leonardo is quite a helpful resource on those sorts of issues as well. Next slide, please. So just some practical points. I've emphasized really the key point about fraud, which is that it's very, very difficult to succeed on. So some observations. Well, it depends which side of the fence you're sitting on, but if you are the party making the case, you'll need to raise fraud at the earliest opportunity, and you really will need completely compelling material. You will need to establish effectively that you've caught the beneficiary red-handed, is my way of looking at it. You can, as the challenger, pose legitimate questions. You can point to documents that raise questions about the genuineness of a call, and the English courts would expect those questions to be answered. And if they're not, it can be a ground for drawing inferences. But it's very, very difficult. Flip that on the other side of the equation. What are some of the practical issues if you meet a fraud case? Well, one of the problems with this is it's very unpalatable for most parties to be dealing with fraud allegations in a public forum. It's an unfortunate feature of the bond landscape that many parties select confidential arbitration for their underlying dispute, but the bonds that are ancillary often have court jurisdiction clauses. So these issues can be played out in public when that's not desirable. And another issue with confidentiality is the underlying project, by its nature, sensitive and confidential. And that can pose a challenge because there's a tension between meeting the fraud case, but not divulging reams of sensitive project information when that was never intended to see the light of day. Nonetheless, as I said, if there is a challenge to the integrity of the call, it needs to be met. And the focus there really should be on the belief that the party had that they were within their rights to make the call. Internal record keeping can be helpful. I'm sure there's going to be a lot of references to records at London Disputes Week, but this is no exception. If you have the opportunity, or as an advisor, if you have the opportunity to advise, it's a good idea to make an internal record of the reasons you're making a call and to document that in a way that you would be content to disclose. Now, that is something that butts up against questions of privilege, and you need to take careful advice on legal privilege. But in the end, if you can produce a document in a situation where a call is being challenged that shows that you've made a contemporaneous record of why you honestly believe that the call is valid, that's a powerful tool. And in the end, my own view is that less is more in these situations. The test is so high and so difficult to discharge that this is not the right forum for extensive, voluminous treaties trying to deal with the fraud allegation. It's really a question of doing enough to take it seriously and show the tribunal that you're acting properly. I think I'll move straight, because of time, to the next topic, which is injunctions in the English courts. So next slide, please. There's a degree of overlap with this section with some of the things that James has covered. So I'm just going to focus on this decision, Shiporgy and Young, which I think is the latest law in this area. And it's a case in which I appeared last month, and indeed the dispute is rumbling on. The first thing to say about this, okay, well, the facts, just very briefly, it concerns a power plant in Rwanda, and there was a $32 million on-demand bond, which was called for issues associated with delay and other breaches. The parties have selected ICC arbitration for their disputes, governed by English law, but in a Singapore seat. The demand bond, in contrast, was an English law instrument with an English jurisdiction clause. So it neatly illustrates that dichotomy that I was referring to a minute ago. And hence a chapter of this saga played out in the English courts on the demand bond. Next slide, please. It's an interesting case because it ties together a few of the themes of today. One thing I should just say up front, as this is London Disputes Week, International Disputes Week, it's a great advert for the English courts. And the speed they can act with. We had two parallel sets of proceedings issued on the 29th of March and the 30th of March, respectively. We had a first hearing on the 31st of March, we had another hearing on the 1st of April, and we had judgment by the 6th of April. So a really impressive, responsive and agile effort by the judiciary. The next thing to say is the judgment's quite a helpful document for anyone looking at a similar issue, because what the judge did was give a categorization of the different stages in the bond call process at which a challenge might be made, and he called them A, B, C, D. So if you've got a situation on your desk or you are contemplating a call, it's a useful resource, because what the judge does is for each of those different sort of variants on the fact pattern, he signposts the key legal decisions and he signposts the key questions that arise. The core issues were whether or not there was any basis in English law to injunct the demand. And the answer in the end was held to be no. And in reaching that answer, there was a pretty emphatic endorsement of what's referred to as the enhanced evidential standard. And what we mean by that is that injunctions in this area are harder to come by than in the general run, because whereas in an ordinary situation for interim relief, the English law test is to show a good arguable case on the merits or something similar to that. Here, where you're trying to stop an autonomous demand bond, you've either got to show a compelling case on fraud, as I've explained, or you've really got to positively establish that there is some term in the underlying agreement that actually prevents the demand from having been made. And the judge went through all that law and endorsed it and affirmed it. Next slide, please. And one of the reasons he had to do so was because of the arbitral context. And the other reason Shiporgy is an interesting decision is that for anybody with an arbitration practice, it explores the interplay, the intersection between the court's enforcement processes and the powers of arbitrators. What was argued by the contractor, or let me take one step back. What they did here was they launched parallel pathways. They made a claim in the court to try and stop the bond being paid out, and they made a claim in arbitration to essentially for relief relating to the demand itself. And I can make reference to that because it's referred to publicly in the judgment. And so you have these two twin paths going along. And what the argument essentially made was that the court ought to take a slightly different approach where the bond was the subject of an existing arbitral process that was just about to kick off. And the emergency arbitrator might take a different view. So the argument was ultimately there should be a slight relaxation of the principles that James and Fiona and I have been discussing, where the context is a broader arbitration. And it was therefore technically an arbitration under section 44 of the 1996 Act. And the court rejected that. And that's quite an important finding. Even though the court accepted and acknowledged that an arbitrator might apply a slightly broader framework, the kind of transnational standards that one encounters in things like ICC arbitration for interim relief. When it came to the English court process, the court zoned right back in on the legal principles of substantive law that we've been talking about and affirmed the stringency of English law when it comes to demand bonds. And next and final slide, please. A few sort of interesting offshoots for further consideration, I think, on another day. The judge in making that finding was influenced by the fact that this emergency arbitration proceeding had only just been brought, it only just started at the same time. And that raises the interesting question of whether if arbitration proceedings were more fully on foot, would the court behave differently in response to a bond call that was trying to sort of preempt or in some way second guess the arbitration? Possibly, I think, is the answer. But nevertheless, the judgment is a pretty powerful affirmation of the robustness of the court's attitude. Secondly, you've got an interesting arms race, as I've described it here. The court ultimately set its face against granting relief on any more expansive basis than the strict grounds we've discussed. And if that is right, will that encourage parties to be more preemptive within arbitration? So if you know you're not, to put it colloquially, if you know you're going to really struggle to get a good answer out of the court, will the party that wants to challenge a demand look to act more preemptively to anticipatory challenges within arbitration and to try and take advantage within that forum of a broader approach? Seems to me that is a possible ramification of this decision. And in any event, what those sorts of arguments raise are very interesting and sometimes very difficult questions of the relationship between the law of the bond, the law of the contract, the law of the seat, and trying to map through that potential source of conflict. I can't discuss the ongoing Shiporgy case, and it's confidential arbitration anyway. All I can say is that there are some very interesting issues of that species in play, but in the end, they all turn on the particular choices of law and the particular dynamics of the particular case. But it's an interesting decision. It affirms the stringency of English law when it comes to getting injunctions on demand bonds, but it explores some of those interesting points of crossover with arbitration. And that, I think, concludes the slides, but we've left space for questions and discussion. And as I mentioned, the question and answer panel has lit up, for which very many thanks. And I'm just going to skim down. I mean, Fiona, before I go into any of those questions, is there anything you wanted to say to draw things together?
No, Simon, thank you very much. And thank you, James, for your presentations. Extremely interesting. This is a rich subject, as witnessed by the number of questions that have been generated by the delegates. So thank you to the delegates for those. Perhaps we have a very few moments left. Perhaps we could look at some of the questions that haven't been covered by what you've said. This is a question about the situation where the bond incorporates the URDG. And the question is, if a non-compliant demand is made, is there any reason why there can't be a second demand which is compliant? I don't know which of you is best placed, perhaps.
I can deal with that very shortly. The answer is no, and one would expect if the bank rejects a demand, as I said earlier, it's required to state why the rejection is made, and I would expect the beneficiary in that instance to very swiftly make a revised demand. Whether or not it agrees with the rejection, you can deal with that later. Make a revised demand addressing the reasons for the rejection. So the answer is no.
Thank you. And I think the next one is possibly also for James, actually, because you spoke about the wider small p political and commercial context in which these instruments are activated. Yes. And you mentioned reputational damage, I think, for the beneficiary. The question from Joe Kelly is, how does the cashing in of a bond affect the credibility of the party who cashes it? So the beneficiary. Will that not affect the ability of that party to get guarantee bonds and to get institutions to issue bonds to it?
Well, I think, I mean, look, how it affects the ability of the beneficiary or the payer to get bonds will, of course, be very specific to the surety and the particular circumstances. But I think it's unlikely, in my experience, to affect the ability of the beneficiary to get the appropriate security in the future, because, of course, the reason it's called the bond in the first place is because the principal has done or has not done something that it ought to. So I don't think there's circumstances where the beneficiary would have problems. Not so for the principal, I would suggest. The principal, I mean, look, these demand bonds, because they're being called more and more, are getting very expensive, and parties are now looking to alternative means to provide security. You know, maybe it's a payment into an escrow account that can be triggered on the meeting of certain conditions, but the on-demand bonds are getting more expensive. And of course, it's right that if the principal is the subject to repeated successful calls, then it is going to be much more difficult for the principal to obtain that sort of security again. And that's the case even if the principal goes to a different surety, because the surety, certainly for bonds of any significant value, will be keen to understand the history of the principal. And you know, part of that is whether the principal has faced successful calls in the past. So I think beneficiary probably not, principal almost certain.
Thank you. There are a couple of questions which raise very similar considerations. They posit the situation where a call is made on a demand on a bond, and the surety, the payer, pays out. It is later discovered that there was a problem. For example, the call was in fact fraudulent. But by this time, the beneficiary has gone into insolvency. What can the payer and the principal do then? Perhaps Simon, do you want to tackle that one?
Yeah, it's a key question, and it's, in a sense, the answer is not much. What one has to remember, I think, is that these demand bonds ultimately are an expression of the allocation of risk between the contracting parties. If contracting parties agree that their security rights will exist in a demand bond, there is an inbuilt risk within that framework that a call will be made and that call will turn out to be unjustified, but that by the time you've worked that out, the money's gone. And it is for that reason that they are, as I think James put it, you know, they are a very powerful weapon. They're a sort of draconian instrument, it could be said. A performance guarantee, to give you the counterpoint, somewhat lays off that risk, because the payer isn't ultimately going to pay until it's been finally established, subject to the wording, of course, but the payer is generally not going to pay until it's been finally established that, yes, there is liability. But in a demand bond, that inquiry is bypassed. Their whole purpose, their raison d'etre, is to provide interim cash quickly in order to keep these projects going. And it's a corollary of that the insolvency risk generally will ultimately sit with the principal. So yes, that unfortunate situation that the questioner or the questions posit, you know, is one that's very real and can arise. And of course, it's often put forward as a sort of relevant factor in the arguments about whether an injunction should be granted. But in the end, as I say, it's an expression of the allocation of risk that the parties agreed to.
Thank you, Simon. Well, I think we're about to be cut off. We really have run out of time now. Unfortunately, we haven't been able to answer all of your questions, but thank you very much for them. And thank you to both our speakers. As I said at the top, the slides and a recording of this session will be sent out by email to all the delegates, so you can enjoy them also at your leisure. Thank you very much for joining us this morning. Goodbye.
Thank you, Fiona. Thank you, everyone.
Thank you. Good morning.